Thank you very much, Nico and Verena, for your presentations this morning. I would like to start a short discussion. If there are some questions from the room, or maybe also from online, if it's possible. And if you allow, I will start with the first question. Because at the beginning of the presentation, there was sort of very short presentation of what can be a judicial expert, like technical expert, expert witness, and legal expert. Legal expert, from my understanding, would be someone who answers a question about foreign law, for example. It's the only possibility I can imagine a person dealing as an expert for a court in legal aspects, because the court actually is the expert in legal matters, apart from maybe foreign law issues. So I think legal expert is probably only the case where a person gives an opinion about foreign law. But what about technical expert and expert witness? We know that in some countries, actually, from my understanding, rather common law countries, but probably also Spain, there are experts that are not appointed by courts, but appointed by parties, and then the whole process is made in another way. So the expert witness is considered as a judicial expert, if I get it well, but how can it be compatible with the aspect of independence you mentioned also? I think this was really also a question within the working group, and maybe I would like that we say a little more about this today also, about independence for expert witnesses.
In common law systems, is my microphone working? No? Comparable.
It's also a nomenclature and it's also a translation issue. As we see in the United Kingdom, you see the explicit use of expert witness, and the expert witness is paid by one of the parties. Although we see that the independence and impartiality for the English in the bottom of his system, is in the bottom of its DNA. So there is no doubt in the United Kingdom that an expert witness is independent and impartial, although he is paid by one of the parties. And there we see the nomenclature, and we look at the experts in the local legal systems in the member states that advise a jury or a judge. And that means that is I think, the criteria for being a judicial expert in the way we say judicial expert. So it's nomenclature and translation.
Thank you very much for your answers, and I would like to give the floor to people in the room if you have questions, and please, if you may just stand up and present yourself so people know who is speaking.
Yes, my name is Michel de Wolf, and I am a member of the jury coming from Belgium, and I'm a judicial expert, an academicus, and also a part-time judge. I have a fundamental question about the aim of having a list of experts at European level. And I think it's the aim of the project to develop a European profession. Mais dans ce cas-là, je ne parviens pas.
In this case, I don't understand that you propose
I cannot understand if this is the goal, to develop a European profession with a European list of experts, that you propose sometimes to not take the higher standards about experience, about training, and so on. In my opinion, there will be success only on the basis of the highest quality standards. You may not convince the countries where there are the highest standards to accept, to decrease their standards. I think this is unlikely. And also, there is another problem, that why some countries are not implementing today the highest quality standards. Why? By conservatism, by tradition, by justice today. And as I have said, I am a judge part-time also. Justice today must take back its higher status in many member states. And then I think it's not good for justice that judicial experts will be of a lower level than the parties, than the technical advisors of the parties in themselves, than the lawyers. The lawyers, all of them, have an academicus degree, all in Europe. And they have also a training, an experience. So this is my question. Why don't you go fast to the highest quality standards that you can observe? Of course, it should not be the highest in all cases, but the principle in why not to go on the principle to have something that is favoring to go to the best than to the lowest of what you see in Europe. Thank you.
Thank you. That was a lot of questions. Thank you. First, I would like to state that within the EEEI, we speak of registries and not of lists of experts. Well, it's in the name, but the name, that's important to us. A list is just a list. I can write 10 names, and that's a list. If I have a registry, I have criteria. If we have... I have not made my intervention in French. Okay. But just to make it sure anyway. Then you ask something that may be even politically driven.
Yes.
If in our project we are going to find the highest standard and sort of advise everybody to be of the highest standard, a lot of countries will say, we will not be able to make that. Thank you very much. Goodbye. We'll see you in 10 years. However, we try to find a common level, and we see that some of the countries do not meet a common level or the lowest standard. Setting the lowest standard for professional judicial expert means that some countries will go up, but the better countries do not have to go down. Later today, you will see the IT tool that will be presented, and we see where we gather information of several countries, and we show what type of experts are working there. And I do not share your fear that the countries with higher standards will say, oh, if that's only the minimum, we will leave the rest. Because the judges in these countries will not accept this. The thing that we do reach with this is that when I have to go to court in a random country, Hungary, I would like to know that the expert working on my court case there does meet a certain minimum standard. And you know, at the moment we have standards, we can raise them over the years.
Yes. And I would also add that we are a mix out of different countries, different histories, languages, cultural behavior in different countries. And yeah, it's the aim of the project is not to go one size fits all, but to find like common ground and start from there. And also we have no jurisdictions. All we do is make recommendations. So we don't say every country should absolutely change their legislation at this point. That's not the point of the project.
I see a question there.
Vous m'entendez? I can speak French because I am fluent in French, but you must translate, please. It's possible?
So the gentleman is going to speak French, so you will have the translation in English, but you all, if you don't speak French, if you're not fluent in French, you will need some headset. In reply to your question, I'm an IT expert, quite senior, old, but honorary expert. So I would like to reply to your question. 4 or 5 years ago, 6, 7 years ago, we had a quite naive approach, like the Belgian participant just showed, if I humor him. We thought we needed a minimum standard applied all through Europe, and the European Commission tried to implement this with a publication in English called The Best Practice, and it's been translated in various languages. At the time, the European Commission consulted us and told us, well, it's not very good to propose European countries or member states best practices. So we now have another project, and we try to find a new tool to bring improvement and new ideas to other countries. So we've stopped talking about best practices. We just want acceptable practices. So that can be accepted, and that could allow some member states and some instances working in these states to improve. So it's a very practical approach. So within the Institute, one thing is clear. We want to reach as many people as possible. And for this, we are using a tool. Initially, we are a think tank, but now we want to create a tool to bring out, to transmit our ideas from the think tank, and also to have them adopted as much as possible throughout Europe. But then again, you have also to discuss with the European bodies about this.
Thierry Hochheit, member of the jury. Perhaps the solution to the problem raised by Michel is a question of transparency. We are going to define criteria, and we will find those criteria in the registry that will be addressed in the different countries. So when I want to appoint a Hungarian expert, a Greek expert, a Finnish expert, I will see in the Hungarian registry either an information, all the experts on this list fulfill these criteria and do not fulfill these criteria, or perhaps even this information per expert. Expert A fulfills these criteria, and expert A doesn't fulfill these other criteria. So it's a question of transparency to allow me as a national judge to appoint an expert from another country where I see that he meets the criteria I, under my national law, would require from an expert, from a judicial expert. Perhaps that's part of the question, the answer to the problem raised. Thank you.
Yeah. Just a small addition to that is that later today we will also look at the criteria, other working groups look at the criteria for the registries in the local countries, so that if you find this registry, you will know that also the registry itself has met criteria, so, in addition.
To whom may I pass?
Hello everybody, I am prosecutor from Polish National Prosecutor Office, and I have very practice question, because I was impressed that if you talk about expert, you mean a physical person, but during the process I have cooperated with thousands of experts from many scientists, cyber experts, medicine, etc. Very often we use a specialist institution like lab and etc. And in Polish crime procedure we can find expert. In Polish we call biegły, specjalista, which is a physical person, which is a specialist institution or science institution. And often this kind of bodies have very big and very good devices, so we must use them for our process. So my question is, do you mean that in this list should we have this kind of bodies, like legal bodies, for example? Sometimes commercial bodies, sometimes are bodies connected with public resorts, because for me it's obvious. Thank you very much.
I think the most important thing is that we do not interfere with local law. If you have a local law that prescribes a judge to use a certain type of expert, we cannot change that. We cannot advise against that. However, if we look at the person of the judicial expert that will be writing his expert opinion, there we have some advice on the end of the project. So then we do hope that also this minimum criteria will reach also those organizations that you must use.
Also, we found out by the questionnaires that there are, in fact, the bodies you described in most of the countries. So there must be a reason for this, that this makes sense. Yeah.
I think we have also a question from online, and so
Pavel.
Aurélie will ask them. Maybe Pavel first and then question. Yeah. Okay, thanks.
So we have an online question concerning the concept of disclosure and the application of this concept to the standard of independence and neutrality.
The non-disclosure as an expert.
Disclosure, yes, which is a concept applicable to mediators and arbitration. And our online participant asked if this concept could be applied to judicial experts.
I think that the questionnaire showed that most time, like some kind of non-disclosure agreement is kind of existent within the criteria of impartiality and independence.
It depends. We know there are countries who, and even certain professions, who use a disclosure statement already.
By law,
in their,
sometimes by law.
And sometimes by law. But in many countries it's not obliged, and that I think that relies is working with the way the expert is chosen and appointed. Like I give a Dutch example. Before an expert is appointed, parties can talk to the judge about this expert. So any disclosure problems will be filtered out in this procedure before, most of the time. But disclosure agreement, disclosure statement, I am for it to put it in your expert opinion.
And sometimes it goes along with a profession, like a doctor is per se, per law, not in the position where he would talk about anything outside of the court.
If I may maybe shortly explain, if I understand it well, disclosure would be the fact that the expert at the beginning or before starting his work says, I have maybe some history with some of the parties, this is what happened, and I feel unbiased in any way, but I say this is how I am in connection with some parties, but it's okay for me. If it's okay for you, I will take the mission.
But
this would be a disclosure.
That is impartiality most of the time.
Okay, but the question would then be, would one recommendation be to impose such a disclosure statement to the expert before starting his work? We can put that to the jury.
Possibly, yeah. If that comes out of our conference, then we write it. We investigate it and then we write it.
Are there other questions?
Just to add information concerning disclosure, our online participants give a definition of disclosure, and he explained that the duty to disclosure is a kind of continuing obligation throughout the process.
Thank you very much. We had a question from Pavel. Maybe if we get back to you after.
Good morning. My name is Pavel Rybicki. It is not a question, it's a comment. We are talking about minimum standards, and it is probably kind of misunderstanding with the term, because minimum standard is a very technical term standing for the number of requirements, that they are possible to compare between the countries that we are taking into comparison. It is not the lowest quality standard anyhow. It does not fit to this kind of criteria. Minimum standard it doesn't say anything about the grades. It is only the number of the requirements that are easy to compare between the objects that we try to compare. And I'm saying that because in the other presentations, this term minimum standards will repeat and repeat again. So it is better to precise from the beginning what it is. Thank you.
Thank you.
Hello everyone, I'm from France, from the Ministry of Justice. I have a question about one of the criteria you discussed, the criteria of basic knowledge of legal procedure, the legal system. And I think it is very relevant if you appoint someone from your own country, and it is one of the criteria in France. But I thought of something. Let's say, for example, I'm a French judge, and I have to deal with a case about very famous Polish painter, and I need a Polish expert to tell me if the painting is genuine or not. And the most qualified expert is from Poland because it is a Polish painter. But if I have to appoint someone, a Polish expert, and if he has to know the French legal system, I'm not sure there will be many qualified experts from Poland who knows the French system. So isn't it a problem if we think about European experts?
That's not how we meant it.
Oh.
The Polish expert won't have expertise on French, German, Lithuanian legal systems, but if he is very grounded in his own Polish system, which is a democratic system, then that's already some kind of an asset, which helps in other countries too.
Yeah, no addition.
Did that answer your question? Somehow.
Yes, please. Good morning, everyone. First and foremost, I'm Francesco De Pasquale. I'm from Malta, the smallest country in Europe. And I'm also the president of CEPEJ, but I'm here as president of CEPEJ, but also as a Maltese judge. And I have to say, first and foremost, this work group and this report is very, very interesting. There's a lot of food for thought. which means that we're going to have to work quite a lot.
Okay, put the microphone.
But there's a lot of food for thought, thank you. I was just wondering whether you would be able to make also available the raw data of all the information you got, all the results for the questionnaire. And I'm telling you this for one simple reason, which maybe I even understood for Jean Ramon. You know, I come from CEPEJ, and at CEPEJ we try to share the best practices that all the other countries do. And we'd like to sort of, you know, share with all the other countries how they work and how they don't. So if you would be able to make that available, other countries could learn from other countries. And then I will join with what Martin pointed out before, that you try to put up the level. The only way people can put up the level by knowing how the levels are put up in other countries. That would be the best way to teach people how to put up the level. So if maybe you could also look into that, that could be another interesting thing we could think about.
I was also appointed privacy officer of this project. I will look into the GDPR rules, and then we'll see if we can send the questionnaires to CEPEJ. Because there might be personal data in there, or only to the jury. Okay.
But a lot of information is already online.
I think the questionnaires
From the
will
project. Okay, yep.
Are the questionnaires in the project?
Not the questionnaires, but the information which we used to fill out the questionnaires.
Always in French, I am going to try to reply to my friend Francesco. Nous travaillons.
We've been working with CEPEJ for 10, 12, 14 years. Our principle is to exchange all our data. So you're very welcome to do so. We will give you all the data you need. Everything is published on our site, but we'll gladly share them with you. I know you are the CEPEJ president. I take note of this, but I would like to remind you that we also create the evaluation form for the evaluation of experts in Europe. So we'll do our utmost to facilitate your work. Do not have any doubt on this, please.
My name is Guido Alpa. I am a member of the jury. I have been president of the Italian Bar Council since many years, and so I noticed that there is a great difference between the treatment by local laws of traditional professions and new professions. And I wanted to know whether you have noticed a difference in the treatment of experts if they come from traditional professions, for example, lawyers, engineers, architects, and new professions like informatics or expert in informatics, artificial intelligence. Just to explain, according to the state law in Italy, traditional professions require a degree, training, a state exam, and then continuous professional development. So all these requirements which you suggest for experts are already satisfied by local laws concerning traditional professions. I don't know what's happening for the new professions. For example, for an expert of informatics who is not requested to have a degree or not to keep an exam in order to practice. So there could be a great difference between traditional professions and new professions. So our requirements should be requested to all of them, and so in order to increase the level of the quality of the experts. This is the first question, whether you have noticed the differences between traditional and new professions. And the second question? If you think that it could be necessary to study also rules concerning the way in which experts do their work according to the rules of civil procedure. For example, we think that experts should, appointed by the judge, should, before giving their record or the research and the report to the judge, discuss with the experts appointed by the parties, taking all the documents given by the judge and share documents outside, taken outside the court, share the documents with the other experts in order that there is a free discussion between the expert appointed by the judge and the experts appointed by the parties. So I don't know whether you have studied or compared the rules concerning the way in which the expert should do his or her work under the control of the courts and in the discussion with the parties. And another point, I have not seen whether you have controlled in the section of disclosure, which are the relationships between the experts. For example, the expert appointed by the court could have had other professional experiences with the experts appointed by the parties, or the expert appointed by one party could be the master of the expert appointed by the judge, who is his or her pupil. So between the experts there could be relationships before doing the expertise, which could in some way include partiality or independence.
Yeah, but for all of these problems are national regulations, and we don't want to overcome
but if
those.
we ask to disclose all the relationships that the expert has after he or she is appointed, has had with the parties or with the experts appointed by the parties. So
Yeah, these are different legal systems.
yes, but usually it is difficult to find detailed rules in this, from this point of view.
Do you want to answer it?
Buongiorno, I am Angela Scala and I'm an expert from Italy. Yeah, I want to make this question because it's connected with your thinking about the criteria of impartiality and independence. The question is, an expert, a judicial expert who work habitually with judges in material, civil, and above all penal, in a choice in the beginner can work for the party too, or not. This is for me the question important for the choice of the career of the expert. There is a conflict for an expert to choose to work for the judge, or it depends on the rule case by case, or you must choose if you are impartiality, independent, you collaborate with the judge and none of the party, with the party, with the, you, I don't know if it's clear my question because it's for me a question.
I'm not sure if I understand the question. It is about a certain expert who works for a judge a long time, many years, or it works in a company?
Oh, is it about private parties?
Only for the judge and not for private parties.
That is a very ongoing debate, and now I go outside the project, but I go into the Netherlands. Yeah. We have this same debate with experts working for insurance companies. I do not judge them, but they are said, you work only for this insurance company, you cannot be trusted. So that is amended by the fact that we can always have a second opinion when you have an insurance debate. But in regular discussions with regular experts, I would say, if that is the case, do not take the mission. Then you are probably not independent and probably not impartial, and you have a conflict of interest.
And your first question concerns some kind of differentiation between traditional experts and experts of IT matters, because Nico, you are an expert on IT matters. My understanding is that there's a common stipulation in each country, procedural-wise, for experts.
If we look at the traditional experts versus the new let's say IT or artificial intelligence, of course, if we look at the demands we ask from experts, we say you have a professional knowledge on one hand, and you have your skills and judicial knowledge on the other hand. So if your professional organization is granting you the knowledge to have enough knowledge in the field of IT and artificial intelligence or scientific, chemical, whatever new field, that is on the basis of the profession. It does really not interfere with the fact that you know of judicial procedures. You can learn continuous professional development, you can have continuous professional development and still be the same judicial expert over many years. As we said, the half-time of judicial knowledge, judicial procedural knowledge, is usually very long, and in the technical field it's shorter. Does that answer your question? Thank you.
How are we time-wise, Beatrice? Should we move on? Or
last question about criteria, because we must know this criteria is only a help for prosecutor or jury. The last decision, if I want this expert or not, is my decision, and I must check if my country I can use this expert. So it's only a proposition, also a point of view, but I am obliged who I used in my cases.
I am not sure whether the EU expert we are building is going to be transported to the countries. Furthermore, I more look in this fact that if citizens from abroad come to court to my country, the EU wants to be clear that the EU citizens from the other country knows what is going on with the experts in the court case. So if I am in Poland and go to court in Poland, I do not bring my own Dutch expert. A Polish expert will be appointed. And then I want to be able to check for my confidence what is the matter with Polish or Hungarian or Romanian or German experts. Yes, so I think the citizens are traveling and the experts will be working in their own jurisdiction. Does that answer your question? At least a bit? Yes. Yes. It's your decision. It's the jury. It's the judge's decision. It's the same question of the French judge. It's the decision of the judge who is appointing an expert. We're only providing a tool or a helping hand in how to assess the quality of this, and then it's the minimum quality of this expert.
Thank you very much. We will take two last questions from online. Then maybe if you accept, we would go over to the coffee break and make the presentation of Working Group 2 after the break. Did you have also one question? Okay, then three questions.
So first, we have a question from Rafa Orellana, who is a Spanish expert and lawyer. And his question was about the clarification concerning professional confidentiality. Are judicial experts subject to professional confidentiality? And how can this standard be respected by judicial experts?
Yeah, I think we already said something to it. Some kind of different obligation in different countries, either by law, by profession, by procedural law. And it's also part of impartiality, I guess. And there's also general data protection.
As I'm thinking about professional integrity is very hard to measure, of course. But professional integrity starts with, I think, a declaration of good conduct, which is stated by the official in the country. And then furthermore, it's most likely, but I'm not really sure, if you are still a member of your professional organization, that's mostly the setting where a non-integer or non-professional person will be kicked out. And if that is so, he will probably also not be appointed as a judicial expert again.
Plus, if you're professional, the GDPR is applying to you within Europe. Is that true? Yeah. For an expert, the data protection guideline in Europe is applying to you.
Well, the GDPR is applying to everybody.
Yeah.
But
so that would protect everybody in court and their data and their stories and their cases too.
The second question is from Aneta Caracas from Croatia. Is it possible to organize a meeting of experts of certain professions online at the European level? And what do you think of this opportunity to talk about these standards?
I mean, it would be wonderful if every expert branch would talk about our standards. We wouldn't say, no, please don't mention them.
Yeah.
One last question.
Yes, I would like to say that I agree with the solution proposed by the Luxembourg colleague. Because I understand that you want not to lose the member states who are for the moment at the lowest level, but do not forget also the other ones that can be lost if the standards are too low.
There are also best practice examples in these presentations.
So the solutions may be indeed for some criteria. For instance, because I don't speak about all the criteria, but the basic one, like what is the use to have an expert with no experience? What is the use of this? So if we have a criterion saying that no experience at all is asked by some countries, then you may have, according to the Luxembourg solution, if I may say like this, okay, the criteria is to have some experience, but somebody who is not, according to his national law, asked to have such an experience, it should be disclosed. It should be transparent, as it has been said. It has to be transparent that this person on the registry does not meet that criteria.
I wrote down. I wrote down
Nico,
one advice.
Nico,
is that
Nico,
no,
Nico,
no, please,
one
please.
minute.
No, please.
Just a very short response about your question.
Jean-Raymond, please, one moment. The question was asked to the speakers.
I finish. Thanks. Just an answer to your question. There is a project. The name is FindexII. There is all the process, all the status, all the criteria of the 22 countries, and they are on the e-justice website. So you can see what's the level of criteria of each country on the website.
I was going to say that I noted that I wrote down that we must make some criteria mandatory, because I fear I understand your fear for minimum criteria and that we lose some of the higher. So I wrote down some criteria must be mandatory. The other thing that I would like to respond, and that's probably, we're way over time, that we did look at local laws for, let's say, education. And we cannot say anything about this because it's not the project, it's not our task, and we cannot say anything about local laws on education. So if the education level for a certain profession is in a country, to our opinion, very low on us, that's not what we go. If that is the professional standard, that is the professional standard in that country, in that member state. Yes? Thank you.
Thank you very much for your participation, all of you. We will have a short coffee break. Please really come back at 11:10 past 11 at the latest, so that we can have the presentation of working